So oftentimes when you find a case on Westlaw that you like, the next question is how do you make sure that it's still good law? And so this process is sometimes called shepherdizing or key citing, but again the idea is now that that case has come out, how have other cases reacted to it? So in my example, I'm going to be looking at this case, Preeb v. Nelson, and you can see that there's a yellow flag. So the yellow flags are always going to give you a quick visual indication of whether or not this is still good law. To see all of the different flags that are available on Westlaw, you'll see this little Powered by KeyCite logo. If you select that with your mouse, a box will kind of pop up. And here you can see a yellow flag means that it's still good law, but it's been limited or distinguished in some way, so maybe another jurisdiction doesn't follow it, or maybe the same jurisdiction said, yeah, that's a good case under those circumstances, but we have slightly different circumstances. A red flag would let you know that something has been reversed or overruled, or perhaps if you're in the state of California that it's an unpublished case. Based off of California court rules, we're not supposed to cite to unpublished cases as authority. And then the blue and white striped flag, which you'll see more rarely, and that's just letting you know that that case has asked for review from one of the federal appellate courts or from the federal Supreme Court. So as I'm looking at my case, if I scroll down, here's my synopsis paragraph at the top. That's going to tell me my major facts and my holdings. And beneath that, I'm going to have the headnotes. And so I think the default view for headnotes is just to look like this, where there's a chunk of text. But headnotes are going to be very important because those are going to let you kind of see an outline of every point of law that that judge discusses. And here in this case, we can see that there are 6 points of law. Very few people are going to cite to this case for every single thing that was discussed. Oftentimes, maybe you're just going to be interested in, let's say, headnote number 2. So if I like this point of law, if I select that number 2, that's going to quickly jump me to the part of the case where that judge is actually discussing that point of law or headnote number 2. And so you can always use those to jump back and forth. But let's say now that I've read this case, headnote number 2 is the only one that I care about. These other rules are, they're good, but they don't necessarily apply to my facts or my case. So the next step is to scroll up to that top of the case, or, this is a static toolbar, you don't have to. But here you can go to the negative treatment tab. So the negative treatment tab is going to tell you any case that has limited any of the holdings from that case that we were just looking at. So if we were concerned with headnote number 2, our big goal is to make sure that no case has discussed Preeb v. Nelson headnote number 2. And here you can see this case discussed headnote number 2, that one discussed headnote number 2, and the last 2 do not. So if I want to cite to Preeb v. Nelson for headnote number 2, I need to make sure that these 2 cases aren't going to undercut the argument that I want to use for it. So if I forget what headnote number 2 is, if I hover my cursor above it, that'll kind of show me what that is, and it'll do that for any other headnote as well. So that's a nice way you can kind of keep track if you just remember the point that you're trying to discuss. Here you'll see something that says most negative. Now this is just an indication of the most negative case out of all of them that have discussed it. So that could be the jurisdiction that could potentially reverse or overrule it, or the case that used the harshest language. But realistically, what you want to focus on are those headnotes. So I want to see what this case said about headnote number 2 as well as this one. Here I can look at that depth of treatment. 4 green boxes would mean that they have discussed our case for a page or more. 3, almost a page. 2 is like a paragraph, and 1 would be like a sentence or string cite. So I have about a paragraph of discussion here and almost a page of discussion here. Now I want to open up Harris to see how they've discussed Preeb. So I'm going to go ahead and click open that link. This is going to pull up that case on my screen, but realistically I don't really care about this entire case. I just want to see what this case has said about that Preeb case. So you'll notice over here I have the ability to use my search term. If I jump forward, this is where it talks about Preeb v. Nelson, and I can read this and determine, is this going against what I want to cite this case for, or is this something that I'm not concerned about? Is this limitation not really a big deal? If I continue hitting next term, and it's the last term in that specific case, what will happen is that it automatically jumps me to that next case that was negative, and that's Dugan v. Nunes. And if you remember, it was just those first 2 cases that discussed headnote number 2. And so again, I could read this here and determine, is this something that kind of hurts the argument that I plan on making, or am I comfortable in saying that this isn't that big of a deal? And here you can see that I've reached the last term in this second document. So now that I've checked those two cases, perhaps I've read them and I'm not concerned, I don't feel like they're disagreeing with the argument that I plan on making, I'm good. KeyCite is over. All I had to do was to make sure that I didn't have a case that would undercut the argument that I was citing Priebe v. Nelson for. And if both of those I've read it and I'm not that worried, I'm good to go. The other option you can do is citing references. Now, citing references can be helpful because those are going to tell you every single time someone has talked about that case. You're not going to have to worry about if they've cited it in a positive or negative way because it's just everything. And this can be helpful if you know that headnote 2 is really important, but for whatever reason you just can't wrap your head around it. And so when that's the case, when you kind of want someone else to describe what headnote number 2 meant, the best thing to do is to look for a secondary source that discusses it. So secondary sources are going to be like books written by legal scholars, and they're going to talk about the law as it currently stands. And this can be a helpful way to kind of rehear those facts or rehear that argument made by another person, because sometimes that'll make significant sense to us. And so here we can see that this secondary source is talking about headnote 3, headnote 1. If I want just the ones that deal with headnote 2, I'll scroll down and I can see that there's animals as my topic. And if I scroll to the right and choose specify, and here you can see like headnote number 1 is under animals, headnote 3 is under animals, and headnote 2 was as well. So I'm going to choose the specify button to the right. There's headnote number 1. Here's headnote number 2. So I have 10 citing references on that. I'll choose select, and then I'm going to apply that filter. Sometimes based on your browser it'll apply automatically. It just depends on which browser you're using. But this is going to show me a list of 10 secondary sources that talk about Priebe v. Nelson for headnote number 2, or that point of law that I thought was important based off of my arguments. And so you can see that number 2 is going to be listed on all of these. And just like we did with cases, if I want to see exactly what they said, all I have to do is select on the title of that specific document. And once that appears on my screen, of course it's going to take me to the very top. But realistically, I'm concerned about my argument. So I might use that search term to kind of jump me through the different times it's discussed my case. And so that's always something that you can do as well if you're just kind of looking for someone to discuss that case, simply because the way that that judge stated it in his or her opinion may not necessarily fully explain itself to you. Sometimes it's nice to hear someone else kind of say the same thing in different words.